I'm attorney Mark Nicholson from the law office of Mark Nicholson, and I'm going to talk about your Nicholson Nugget of the day. Former NFL quarterback Mark Sanchez just learned what thousands of Indiana residents discover every year. Celebrity status doesn't protect you from felony battery charges. The ex-Jets and Eagles quarterback was recently hit with felony battery charges in Indianapolis after an alleged altercation with a truck driver that left the victim seriously injured, with him, Mark Sanchez, facing up to 6 years in prison, proving that when Indiana prosecutors want blood, they don't care if you throw touchdowns on Sunday Night Football. This case isn't just tabloid fodder. It's a wake-up call for anyone who thinks battery charges are no big deal. Whether you're an NFL star or a regular Indianapolis resident, felony battery charge can destroy your life if you don't fight back immediately and aggressively. Now, what happened to Mark Sanchez shows how fast life changes. According to prosecutors in the probable cause affidavit, Sanchez was allegedly intoxicated when he attacked a truck driver in Indianapolis, causing serious injury that required medical attention. The alleged victim fought back in self-defense, they said, but the damage was already done. What started out maybe essentially as some road rage incident spiraled into felony charges that could send Sanchez to prison for years. The key detail, the serious injury, the single factor that transformed what could have been a misdemeanor scuffle into a felony that carries real prison time, Indiana doesn't mess around with battery charges. And neither should you if you're facing them. Indiana's battery charges will crush you if you don't know them. Here's the brutal truth about Indiana battery laws. They're designed to put people in cages fast. The state divides battery charges into different levels, and each one carries penalties that will ruin your future. First, you have that misdemeanor battery, which maximum penalty is 1 year. Then you have level 6 battery. This is where most serious battery cases land. If you cause moderate bodily injury to someone, you're looking at 6 months to 2.5 years in prison. Moderate bodily injury isn't as severe as it sounds. Broken bones, deep cuts, or injuries requiring medical attention all qualify. A level 5 felony battery, when someone suffers serious bodily injury, the state upgrades the charges. Serious bodily injury usually means permanent disfigurement, broken bones, or injuries that impair bodily functions. The penalty, 1 to 6 years in prison, exactly what Sanchez is facing. So this is the statement from the IMPD's Metropolitan Police Department Chief Chris Bailey. I want to be clear about this. I don't care who you are. I don't care what you do for a living. I don't care where you live. If you come into our city and commit violence, we will use all the tools at our disposal to hold you accountable. So that's what they said, right? Felony, battery charges, F5. That's what he's facing, 1 to 6 years. Now, there's also another level above that, and that is a level 4 felony battery charge. Now, a level 4, that's an offense that results in serious injury to an endangered adult. And these charges can result in a 2 to 12 year sentence. 2 to 12 years. Then you have, after level 4, you have the level 3. The level 3 battery. If you use a deadly weapon or cause permanent injury, Indiana can lock you up from 3 to 16 years. And they don't care if it was just a bar fight or things got out of hand. Then also you have one of the most severe charges for criminal battery is a level 2, and that's if the person is death of a person that's less than 14 years of age. Then you can have a level 2, and that is 10 to 30 years of imprisonment. There's also, you could batter someone that's a child. It can be neglect resulting in death if they think that you battered the person. But the charge would be a F1, neglect resulting in death. And then that, now you got 20 to 40. I mean, it's just, these are very serious charges, right? Aggravating factors that makes everything worse. And Indiana loves piling on aggravating factors that can turn bad situations into life-destroying nightmares, right? Here are the factors that could turn Sanchez's case into a potential 6-year prison sentence. Now, I'm going to be very cautious here. I do not think that when it's all said and done, I do not think he's going to get any prison time. Even if he's guilty of this crime, he hires a good attorney and can get in there. And I don't believe he has any criminal history, so don't think he's necessarily going to get any prison time. But intoxication in Indiana is not a defense, so you can't say I was being drunk or high. That doesn't excuse your behavior. There's actual jury instruction that says voluntary intoxication is not a defense. Involuntary intoxication is a defense. So if his argument is that he was involuntarily intoxicated, there could be a defense there. Now, if it's voluntary intoxication, if he willingly got drunk, then, or smoked dope, whatever. Victim's age and status. Now, you attack someone over the age of 65 or under 14, someone with disabilities, congratulations, you just upgraded your charges. Law enforcement officers, healthcare workers, there are people that are protected class that can also trigger enhancement. Use of a weapon, anything that can be used as a weapon in Indiana. I mean, they can get in there and try to argue a bar or a car or keys, whatever, but normally when you think of use of weapon, you're thinking of a deadly weapon of a knife, gun. I've also seen cars. They consider those deadly weapons, right? Prior criminal history, previous convictions, especially violent ones, will be used to justify, maximum sentences. This is not something that I would say he would fit in that category. If you're a repeat offender, those kind of things, hey, we need to lock this guy up because he's a repeat offender. You need aggressive defense immediately. Now, Mark Sanchez has millions of dollars in access to the legal representation. He's facing serious felony charges. Imagine what happens to regular people, though, who try to handle battery cases alone, or they just try to get the cheapest lawyer they can find who doesn't necessarily know what's going on. The state starts gathering evidence immediately, witness statements, medical records, video footage, forensic evidence, while you're sitting in jail trying to figure things out and what to do next. Every day you wait is another day the prosecution case can get stronger. They're interviewing witnesses whose memories are fresh, collecting this physical evidence before it disappears, and building on narrative that paints you as the dangerous criminal who belongs in prison. Now, here at the law office of Mark Nicholson, we fight battery cases. That's why I'm known as the battery man. We don't handle battery cases gently. We attack them aggressively from every angle because that's what it takes to win in Indiana courts. We hit the scene fast. We try to get all the discovery from the prosecutors. We ask about surveillance footage, trying to gather evidence, take pictures. We've won cases because we found crucial evidence that others have missed, that the prosecutors have even missed. Medical record analysis. Battery cases often hinge on injury claims, and we can bring in medical experts who can challenge the prosecution's injury evidence, question treatment decisions, and expose exaggerated claims that prosecutors use to justify felony charges. That's a huge one. Exaggerated claims. Self-defense strategies. Indiana does recognize the right to defend yourself, but only if you do it correctly. We know how to present self-defense evidence that shows you are protecting yourself, not committing a crime. And the plea negotiation power. If our clients prefer not to go to trial, we negotiate with prosecutors to obtain pleas that our clients request. Prosecutors know we'll fight hard at trial, and we're not just out here trying to have everybody plead guilty like a plea mill. This person's not going to go to trial. They're just going to plead guilty. They're just going to plead guilty. The real cost, though, of felony battery conviction, prison time is just the beginning. A felony battery conviction on your record can destroy opportunities for decades after your sentence. Employment, most employers run background checks now. Violent felonies are sometimes automatic disqualifiers for a lot of jobs. Housing. Landlords reject applicants with violent criminal histories. Finding decent housing becomes nearly impossible. Professional license. Doctors, lawyers, nurses, teachers, and dozens of other professionals can lose their license permanently because of a felony conviction. Gun rights. Felony convictions strip away your Second Amendment right permanently in most cases. Immigration status. Non-citizens face deportation for violent felony convictions even after serving prison sentences. Why just taking the plea is usually suicide? Prosecutors in Indiana offer plea deals that may sound reasonable to scare defendants. Maybe probation instead of prison, or a reduced charge that won't look as bad. These deals sometimes can be traps to get easy convictions while the state saves money on trials. Here's what sometimes they won't tell you. Pleading guilty to any felony, even a reduced charge, still gives you a permanent felony record. You'll check the box if it's on there, a job application for the rest of your life saying that you've been convicted of a felony. You'll lose certain rights and opportunities that may never be restored. People that are accused can fight battery charges because the potential upside, dismissal, acquittal, or reduction to a misdemeanor is worth the risk of going to trial. Now, doesn't mean you always have to go to trial. It may not be in your best interest to go to trial, but you have to consult with your attorney and be honest with them to find out, is it in your best interest to go to trial or to take a plea. Time can be your enemy in a battery case. Mark Sanchez case proves that fame and money don't protect you from Indiana's aggressive battery prosecutions. If you're facing battery charges, whether misdemeanor or felony, every day that you wait without experienced legal representation is another day the state builds a stronger case against you. Now, the prosecutors aren't waiting. They're not being gentle. They're not giving you the benefit of the doubt. They're going to try to fight to get a conviction. And like the chief said, they'll use every tool at their disposal to try to get it. You need attorneys who fight as hard as the state prosecutes. You need lawyers who understand that your freedom, your future, and your reputation are worth fighting for aggressively. Don't let battery charges destroy your life. Whether you're a former NFL quarterback or a working class Indianapolis resident, felony battery charges will ruin your life if you don't fight back immediately. We've helped hundreds of clients avoid or reduce battery charges that could have resulted in prison sentences of years. We know how to find weaknesses in the state's case, challenge evidence, and present defenses that get results. Don't make the mistake of thinking battery charges will work themselves out or that you can do it by yourself. Your freedom is too important to leave to chance. Call the law office of Mark Nicholson immediately at 317-219-3402 or visit thebatterymanlaw.com. That's thebatterymanlaw.com for your free battery charge consultation. We're ready to fight for you, but only if you act now. The state isn't waiting, and neither should you. Now that's your Nicholson Nugget of the day. Please be sure to like and subscribe.